meet you.
Nice to meet you.
You nervous?
A little bit.
Rate your ex 1 through 10.
On looks?
Yeah.
8.5.
What do you think she would rate you?
5, 6.
Who broke up with who?
She done me.
Do you miss her still?
Yeah. I thought it was good.
Really?
Yeah.
I didn't know that. Have you moved on?
No.
Why did you break up?
I think we wanted different things. You can't change what someone wants.
What's your favorite memory with her?
Cuddling, watching movies. I remember when she left, I never felt my bed that cold and empty.
What would you tell her if she was here right now?
I love you. I miss you. Is this making you reconsider the breakup? I think about you all the time.
Yeah, kinda.
I want to go talk to him. And I wish we could be together. Yeah.
Thank you so much for coming.
Thank you.
Great.
Oh.
I didn't know that's how you felt.
I don't usually do this, but nice to meet you.
Whoops. Good evening, everybody. Welcome to Viewers Discretion. I am your host, Joe Neerman, aka Good Logic. Hope your weekend's been going really well. Mine's been going pretty swimmingly. Had a little engagement party this weekend from my nephew, one of my cool nephews. I have a bunch of cool nephews, not going to kid you. This is one of my cool nephews. Definitely qualifies as one of my cool nephews. Definitely. And good people, good food, good company. Everything was amazing. Thank God. Really had a phenomenal weekend. So what that means, by the way, is Tuesday night is when he's getting married. I know. You're like, wait, it's supposed to be on a Saturday. It's supposed to be on a Sunday. That's not how we do it. Okay. That's just not how we do it. So Tuesday night, if I have a show Tuesday night, it's going to be late. It's going to start late. Probably not going to end up having a show. Just telling you now. Because one of the things I noticed that when we go to these family affairs, I don't know why it is, Lady Lawgic, it's just extricating her from these scenarios where she's engaging with her sisters or brother. It's like I need the jaws of life to wrench her away. She very much loves her family, and rightfully so. They're all good people. They're all good people, as are her parents, and she has a very close bond with them. So whenever there's a family celebration, just getting her out before, the staff are turning off the lights in whatever facility we happen to be in. It could be a wedding hall. It could be some other rented facility. It could be a restaurant. It could be a stadium. It doesn't matter. Doesn't matter. Like the lights, like you hear the choom, like the lights go. Like, I really think we need to go. So that being the case, considering the fact that this wedding that I got Tuesday night is like an hour away and it's going to go for like 5 hours. I'm not going to be back before midnight. That's at the earliest. I'm probably closer to 1 o'clock. I'm just being real with y'all. I'm giving you that heads up. So whatever planning you need to do, I know people get all out of sorts. They're like, oh, Joe, I need to listen to the dulcet tones. I can't sleep otherwise. I'm just giving you a heads up. You need to schedule to have, whatever little soft light show you have going on in your room, the mellow music, the crescending waterfalls, whatever it is that you need to get you through when you don't have me to put you to sleep. Maybe a double dose of melatonin. That works for some people. Some warm milk. I don't know. I don't tell you. Yeah. Hey, look at that. It's Branka. It's Branka. How are you? See, the area of law which we're about to talk about here right now, there's really more in my sphere, I feel like, a little than it is in. Whenever I'm in criminal defense, most of the time I got Andrew on here, so we're dealing with some sort of crime. Someone's been popping off the wrong way, and then it's like I'm always left deferring. But over here, we're actually dealing with civil matters, and I'm kind of embarrassed that the solution that I'm about to present to you tonight as to how to end all these TROs is something that I really should have thought of, considering the fact that one of the few cases I'm cited in. I'm not even sure if I'm referenced in it or not. I should be cited in it. I was sitting of counsel. Involves the very rule that I'm going to recommend that Trump use in order to put to bed forever all of these TROs. All of these fights are like, no, we need our money. Give us our money. Hey, you can't freeze our money. All that stuff gets put to bed with 3 words. And that 3 words are injunction bond rule. The injunction bond rule. I'm going to walk and tell you a good war story. Pretty good war story. Not a great war story. As war stories go, I probably have better, but this is not a bad one. It's okay. But it's very, very relevant. It's right on point to where we're going here with how to end all these TROs. Also, Trump, that's the first thing I want to talk with you about is I'm going to be walking you through this injunction bond rule. The second thing that I'm going to be talking to you about is Trump going to Scotus to try and get rid of Hampton Dellinger, which I have to say the first name of Hampton is it's very polarizing. It's either like a really cool name or it's kind of I need to have a poll. Do you think Hampton is a cool name or it's kind of a little gay and not in the good way? I'm very curious. I'm curious. Would you name your kid Hampton? Hampton. Mostly not occult dues. Well, thank you, Fletcher boy. You're on time tonight. The ghetto is waiting. What do you mean the ghetto is waiting? What is the ghetto waiting for? What is the ghetto waiting for? I don't know what that means. What's the ghetto waiting for? It's a little pompous. The actual solution, render unto Caesar that which belongs to Caesar. The things that are Caesar's and unto God, the things that are God's. Separation of powers. Yeah. But that's, you see, yeah, that's an ultimate determinative thing. I'm talking about stopping these TROs cold in their tracks. And I do think we're going to see Scotus weigh in and start, and we're going to see Clarence Thomas and company start saying this notion that any district court judge anywhere in the country can just put a stop on federal policy that's affecting states nationwide is beyond their purview. There's nothing that gives them that license or jurisdiction to actually take such drastic steps. And the only thing they could be weighing in would be perhaps something that affects, to the extent they can parse out elements that affect their particular region. But more gold than what DOGE will find in Fort Knox is going to, trust me. This solution I'm about to give you, it's time for my war story. I think it's time for my war story. So back when I was a young attorney, I was pretty fresh out of school. I graduated in 98, got admitted in 99, and I was working, and after the first couple of jobs, I was working for a small firm. A guy named Jerry Gross. He's a very smart guy, very good attorney. And he really taught me a lot about how to practice law. We had a client who came into us by the name of Michael Block. I'm giving you actual names here because their names are actually on the record in the case I'm going to tell you about, which is Interlink v. Block. Interlink v. Block. This is a case that you'll see came out. We were in the Southern District of New York from Judge Haight, H-A-I-G-H-T, Haight. Interlink v. Block, which frankly I think we made law. I made law in this case, and I actually think that we got away with one because I don't think the law is actually necessarily good law, but not with respect to this element about the injunction bond rule. You'll hear my story, and I'll explain. So Interlink v. Block, this is 145 F sub second 312, was a case where this guy Michael Block came into our office over here, and he was a computer design. He was a program. He was a computer programmer. He spent many years working as a computer programmer. And at some point, this company, Interlink, hired him. And what they were hired him to do is something which today would be to the program they were looking to create is something that is so outdated, probably, that there's probably been 4,000 variations of what he was creating back in 2000, 2001. But what he was working on creating for this company, Interlink, was basically a payment processing center which would charge up someone's account and pay an end user on a monthly basis. It was designed to be basically it's a precursor for monthly charges being hit against your account for whatever service you were charging the person. There'd be whatever. You understand what I'm talking about. It was a money transferring service. And that's what Interlink was looking to get engaged in. And he was creating the computer program for them. He spent 2 years working on this program. And they were marking it out and giving it to various gym memberships and things like that. So this way someone would just sign up and Interlink would process the payment and take the appropriate amount out from the person's account on the 5th of the month, 8th of the month, 26th of the month, whenever it is that was set up. And so this guy, Michael Block, is the one who wrote the program for Interlink. Well, at a certain point in time, they had a dispute because they hadn't paid him anything. And he's like, I need my money. And this company has been going around for a couple of years. I need my money. And they said, yeah, so we'll give you like $50,000. He's like, I was making $75,000 a year before I came here. And I've been working here 2 years. Plus, when you consider what this program is worth to you, it's your entire company. I should be getting more than that. And then, anyway, he said, I'm not taking your $50,000. So this Interlink went to court. And they were very freaked out because what he did was this guy Block, he had a super password and he was able to lock them out of their own system. And that's what he did. He said, I'm not letting you access it. And he would log in there daily to oversee everything, to ensure that that payments were being processed properly, which led them to claim that that's a violation of the Computer Fraud Abuse Act because he's not allowed to be logging in there. And he's like, I'm just trying to make sure that their company doesn't have problems. That's why I'm doing it. I'm not taking anyone's money. That wasn't, other than that which people want me to be taking their money and move it for the various clients of Interlink. Well, anyhow, so this is what was happening here with this whole scenario. And the reason I can share all this with you openly is because all this is a matter of public record if you go into the file. And you can easily find the file over here. I'm not sharing with you anything. I'm not going to share with you any attorney-client privilege stuff. But so this guy, so they end up going to court and they try getting a TRO where they want to force him to give up the password. And they got a TRO. And the TRO that they got said, you have to turn over the password right away because they said our whole company is going to come crashing down if we can't access this. So he came to us. He's like, what should I do? They want me to give over the password. I don't know what to do. So I got to work. I'm looking up this. And what the judge put down there was he said, I'm going to have a security of $5,000 that the plaintiff has to post as a bond. $5,000. What is this bond? What does that actually mean? So I want you to understand that the way the law operates, the purpose of the law is to try and make things as fair as possible for all sides, particularly when we're trying before anything is adjudicated. So in civil court, what they're looking at here is, imagine you're a judge. Okay, let's just like dial back for a second and consider this. Imagine you're a judge. Someone comes into you and says, I have this emergency. I got this big problem, and I need you, the court, to issue some sort of injunction. Make some sort of order that's going to help get me out of this dire situation. And there could be a lot of different types of dire situations, and there's an infinite forms of relief that someone could be seeking. So they say, I have this dire emergency, big massive problems are coming. If you don't come in here, there's going to be a terrible calamity, and I'm never going to be able to assess how much my damages are. It's just going to be the end of the world. So I really, really need you to issue this injunction. And an injunction, as I said, it could either be something that stops the defendant from doing something, or it could be something that, meaning it's enjoining him, or it could be something that's compelling the defendant to do something. Either way, that's called an injunction. And depending on the stage that we're at in the proceeding, they might call it a TRO. In the first stages, they'll frequently call it a TRO, which is short for temporary restraining order. And restraining, you tend to think, means stopping him from doing something, but they'll use the phrase TRO even if they're forcing him to do something, even if they're forcing the defendant to do something. And every time you have to realize it's the defendant who's being forced, because the plaintiff is the one who's coming running to court. It's very rare to have a TRO where it's the defendant seeking the relief. I'm not saying it's impossible, but that would be like where a case has been ongoing for a while. I'm talking about the TRO where you're filing the complaint in large part because you're having this dire problem that you need the court to help you with. So you'll file a complaint, and then you'll file a motion for a TRO. And that TRO is another term for TRO. That's a form of injunctive relief where the court is not issuing a judgment of money, but they're giving a direction and order that the defendant is obligated to follow. And there's different elements that you need to establish if you want to succeed in convincing the court to give you a TRO or any type of injunctive relief. There's different elements that you have to meet, as you would well imagine. So you have to show you have a likelihood of success on the merits, that there's a good chance you're going to win the case. You have to show a balancing of equities, that fairness says that this is that I should be getting this relief. And then you need to show irreparable harm. That if I don't get this relief, there's no way the court's never going to be able to fix this for me later on. And even if I collect the money there's no money, you're not going to be able to figure out how much money I lose out. There's no way to get a real number. So that's the sort of things that will get you. So if you can meet all three of those elements, then you theoretically could get a temporary restraining order or some sort of injunctive relief from the court. Now, many times when the plaintiff's coming to court, they're supposed to give notice to the other side. Many times you don't hear from the other side because they don't have a chance to get their attorneys in there. Plaintiff can walk into court anytime, day or night that they want to, in theory, if they can get in there at night on an emergency basis, which there is such a thing as getting in there in the middle of the night on an emergency basis, or even on the weekends, holidays. In theory, there is such a thing in as far as getting some form of relief. But the point is, you're going to be going into court. The defendant frequently will not be able to get an attorney in there. Even if they can get an attorney in there, you, the plaintiff, has spent the last 6 hours, 6 days putting together these papers. And you've briefed everything, or hopefully you've at least looked at the law. You're able to present you have all your ducks in a row, maybe not perfectly, but you've been investing time and you know what your causes of action are. You're in a very big advantage as the attorney for the plaintiff over the defendant, because the defendant has no idea necessarily. They might get a phone call and be told, go to court, be there in 20 minutes. And they never even heard of their client until the phone call happened. And that happens all the time. So now I have to walk in here and start arguing against someone who's been prepping this thing for the last several days, has researched things. I barely know what the facts of the case are. And I'm supposed to be arguing against him and say, oh, no, don't give him the relief. As defense counsel, you're in a very, very weak and difficult position. So frequently, when someone's coming in there, if they're a skilled attorney, a seasoned attorney, and they're looking to get a TRO, they very frequently will get that TRO. Now, the thing is this. Because the court recognizes, and our legislatures recognize, that this judge is really hearing just one side of the argument. And now he's being tasked, or she's being tasked with trying to decide, do I grant this TRO or not? Do I give this person the relief they're seeking or not? It seems like they're checking off all these boxes, all these elements are being met, but the other side may not be familiar with the facts, or that, these are new theories of law that they're bringing up here, or they might have had a chance to really sit down with their client and present their defense strategies. And I'm guessing, based on what I see here, it seems like they have a likelihood of success. But by the time the case is over, it might turn out that this plaintiff was full of crap, tons of lies, nothing here was truthful, and all the evidence will be on the side of the defendant, and the plaintiff will lose. And then I'll have granted this injunction wrongly, by mistake, because I wasn't Nostradamus. I couldn't tell the future. I didn't know what was going to happen. I didn't realize just how flimsy that, when you really scrutinize and see what kind of evidence they have, that their evidence is basically smoke and mirrors, and that they don't really have enough here to win the case. Well, what happens? So now in the interim, the defendant has been enjoined. They might have been restrained from doing something that they really were legally allowed to do. Or worse yet, they may have been forced to do something that they shouldn't. If everyone knew the case, if everyone knew how things would pan out at the start of the case, the judge never would have forced the guy to do that. So what do we do in order to protect that defendant from a wrongful injunction, in case the judge, when they're issuing the injunction, gets it wrong? The judge should be denying the injunction, but based on the fact that he has limited information, grants that injunction, and now that injunction was an F-up. That injunction was wrong. Never should have been granted, never should have been there at all. Never should have signed off on that order at all. What do we do? What do we do to make this guy right? To make the defendant right? To fix his problem? So what the legislature came up with is they said, okay, when you get this injunction, depending on the scenario, we'll frequently force you to put up a bond, a security, put money in escrow, you can deposit it with the court. You can have a bonding company that signs off on it. And the purpose of that bond is that if the injunction later we learn was wrongfully issued, should not have been issued, that now we have a pot of money there that the defendant can come and say, I was wrongfully forced to do this. Here are my damages that I had as a result of the injunction. I'm taking that money now. So that's called an injunction bond. It's a bond that's designed to protect the defendant in case there's a wrongful TRO that is issued. Okay? So that's the concept of an injunction bond. But what grew from there was actually something called the injunction bond rule. What is the injunction bond rule? Well, what that means is that now that we had this injunction bond, the court has come out and recognized and said, you know what? Whatever the amount of the bond is, that is the cap. That is the most that the defendant can ever come after the plaintiff for if this injunction is later deemed wrongful. If this judge is wrongfully signing off on this TRO, you want to know what the maximum you can get? Whatever he put in that bond amount. Well, all of a sudden now that bond amount becomes not just something that's important as like a safety net for the defendant. This becomes critical. This is everything. Because now, in the case of Interlink v. Block, when they say, hey, if he's wrongfully enjoined, he's losing out, we were saying that now they're going to have access to his program. There'll be access to his work. They'll be able to have their own experts fiddle around with his program. And they're going to rewrite various parts here. It's going to be impossible to show that they basically redid his work. They'll plagiarize his stuff, and he'll never be able to prove that he was the one who was harmed here. So we need them to put up a bond that in case he loses everything now as a result of this injunction. Well, that led to the court saying, okay, well, how much is his time worth? How do we estimate? How do we figure out what the value of his program that he wrote here is? Do we go based on hours worked? Do we go based on how many lines of code? Do we go based on marketability of the program that he created? How do we figure that out? That's the part where we managed to convince the courts the methodology they should use for valuation, that I came up with a case that we presented that we had found somewhere. Because at this point in time, in 2001, that was relatively new information. That was law that was being formed. Now it's well established. Now everyone knows like how you evaluate it. It's like, back then, that was like they were trying to figure out what's the healthiest way to do that. And the judge looked at it as like it's a case of first impression. Like he's trying to basically write the law as to what's the proper way to evaluate a computer program. What's the fairest way to do that? Anyway, bottom line is the judge in that particular case ended up coming out and ended up saying, finding in our favor, he raised that bond up from $5,000 to $200,000. When they saw they had to put up a $200,000 security, they came back to us saying, we'd like to settle with you. But the key part here, which is relevant to what we are talking about here in the context of these TROs that are now being filed to try and stop DOGE from freezing and President Trump from freezing U.S. aid funds, is they go to court and they get a TRO. It's not hard to figure out how much that money is, how much money they're risking. It's actually very easy to figure out. So, if we look at this case over here that I was bringing up here, I'll just come to the senior district judge Haight. So he starts off in his analysis by saying Rule 65C provides in pertinent part no restraining order. This is what's dealing with the law for a preliminary injunction. No restraining order or preliminary injunction shall issue except upon the giving of a security by the applicant, which is basically, insurance, little posting of money there, in such sum as the court deems proper, for the payment to such costs and damages as may be incurred or suffered by any party who is found to have been wrongfully enjoined or restrained. That's what Rule 65C says. But to clarify, the purpose of requiring security prior to the issuance of an injunction or a temporary restraining order is to guarantee payment of costs, that we know the money is there. If I'm wrongfully being forced to do something because the court is now forcing me to do it, the plaintiff is putting up something that I'll be able to get my compensation back if, in fact, I win this case and the plaintiff loses, if I was never supposed to be enjoined in the first place. So it's the purpose of it is to guarantee payment of costs and damages incurred by a party who is wrongfully enjoined or restrained. The sum posted in a bond is determinative of the limit that may be recovered by a wrongfully restrained party. That's the injunction bond rule. Whatever that number is, that's the most you can get back. In the absence of the proof that the movement sought to enjoin with malicious intent without probable cause, recovery by a party later found to have been wrongfully enjoined will be limited to that amount. The risk created by the rule limiting recovery to the amount of the bond is that an enjoined party may be unable to adequately obtain adequate redress, citing Little Tor Auto Center versus Exxon. So you're at risk now that if the bond is too small, you're never going to get that money back. You're screwed. You're up duty creek. The provision in Rule 65C that security shall be given in such sum as the court deems proper indicates the district court is vested with a wide discretion in the matter of security. They can decide whatever they want. A district court may dispense with the posting of security entirely where parties sought to be enjoined, had not shown they will likely suffer harm absent the posting of a bond. But when that number is when that number is easily determinable. So if it's been held proper for the court to require no bond where there's been no proof of likelihood of harm, but that doesn't exist here in the Elon Musk case situation. No one can say there's no likelihood that they're going to end up proving that they are allowed to that they'll be out billions of dollars, tens of millions, hundreds of millions. The district court may dispense with security where there has been no proof of likelihood of harm by the party enjoined, or the court may dispense with security altogether if the grant of injunction carries no risk of monetary loss to the defendant. Over here, there's plenty of risk of monetary loss to the United States if the TROs are issued. And yeah, the district court need not order security with respect to asserted economic damages that are speculative. In other words, if you can't figure out, maybe he's going to be damaged and there'll be some, we can't really figure out how much his damages would be. So in that case, the court can have a lower number. But when the damages are not speculative, when the damages are clear, when the damages are obvious, the court does not have discretion. And this is the key part. They don't have discretion to play around on that number because you're capped at all you can ever recover if the enjoyment, if being enjoined was wrongful. The injunction bond rule actually serves in our scenario here with Trump and with Elon to benefit Trump and Elon. Why do I say that? Because now the court has to come up with a number, which is what's happening is Trump issues a freeze on USAID monies. State of New York comes up and says, oh no, you need to keep paying this, and we think that we're going to win the case. We need to have a TRO. Okay, how much is the bond? Well, that bond is now capping how much Trump and the United States can go after New York if they've been wrongfully enjoined. The only proper amount of the bond is whatever amount of money you're demanding from the United States government. So if they're demanding that $3 billion, $5 billion, $7 billion keep flowing out of the United States government, what if they've been wrongfully enjoined? What if the United States government ends up winning? What if the United States of America wins this case and the states lose? Because the injunction bond rule sets down how much money the government can recover for being wrongfully compelled to ship this money out, the only way that you can actually issue this TRO is if the security matches all of the monies that Trump and the United States of America is supposed to be kicking out. Otherwise, they're never able to recover the monies that they kick out. They have no chance of getting it because the injunction bond rule says, hey, the maximum you can recover is that which is put there as the security for the injunction bond. Which means that now the district court judges are obligated, if they have to make the claim, and I haven't seen anywhere that they have made this claim. Trump and his attorneys need to make this claim that because I don't know if they're unaware of the injunction bond rule. I'm sure they're aware of the injunction bond concept under 65C, but the injunction bond rule is a lesser known element. But because of the existence of the rule, they can never recover this money if, in fact, they end up winning the case. So all the monies that go out between when the injunction happens and when they win the case, they can get back $5,000 of it. But they can't get back the millions, billions of dollars that they're kicking out because of the injunction bond rule. And that's why the bond itself has to be millions, billions of dollars. And if you go to a plaintiff and you say, hey, yeah, we'll give you the injunction, but you're going to have to put up an undertaking. You're going to have to put up a bond for those millions or billions of dollars so that if you lose, the government that's kicking this money out will be able to get their money back from you. Trust me, the state of New York is told, hey, the only way that we're going to stop Trump is if you put up billions of dollars. These 22 states are not going to put up a penny. They're not putting up billions of dollars. That's not going to happen. All of these bonds, all of these TROs will go out the window. Done, finito, kaput. Because if you don't post the undertaking, if you don't post the security, there's no TRO. So what's incumbent upon the district attorney's office and the attorneys for Trump is that they must make a major stink and screaming and yelling, saying, because of the injunction bond rule, we are demanding that the undertaking, that's what the plaintiffs have to take upon themselves. Their undertaking has to be for whatever amount of monies they're telling us to kick out. You want us to put our skin in? You want to force us to kick our millions, billions of dollars out the window? Well, you better have your skin in the game. And hey, if you win, you'll get your money back. You'll get that money back if you win. But if you lose, we have your pot to seize. And you basically are the ones that end up paying them. And if they get an undertaking, a proper undertaking, which is easily calculable, it's not speculative. You can be like, all right, tell us what monies you want us to be farming out. And whatever it is that you're expecting us to be farming out during the life of this TRO, you put that up as your undertaking. These states don't want to have their skin in the game. They know they're not going to win. They don't have confidence they're going to win. And there's no constitutional crisis. It's very simple. Put up your money. You put up your money. You're forcing us to put money out. You put up your money. And if you win, you'll get your money back. And if you lose, then we have our compensation from you. But until you put that money up, there's no TRO at all. No TRO starts until the undertaking, that bond, is posted by the plaintiff. The key is to compel the judge to put up to put down the right number, and by law he's obligated. He can't just randomly come up with like, oh, $10,000. That's not how this works. Unfortunately, too few attorneys are familiar with the injunction bond rule. The injunction bond rule is what dictates how much recovery the United States of America can get if they're wrongfully enjoined here. And it's incumbent upon the attorneys to make a massive, massive stink about it. Because I'll tell you, just like in my case of Interlink v. Block, what happened? As soon as the plaintiffs were forced to put up a $200,000 undertaking, they said, let's settle. Because they're like, I'm not putting up $200,000 here. It wasn't worth it to them. So they said, instead, let's pay him off what the monies we're supposed to be paying him. That's what ends up happening if you force them to put up a massive undertaking. In this one, they'll just leave. They'll be like, all right, forget the TRO. That's what will happen. We're like, all right, we'll keep suing him, but forget the TRO. And there's not going to be any injunction. All the injunctions related to freezing assets will be gone in 2 seconds. 2 seconds. That's how you do it. It's really that simple. I'm kind of embarrassed. I didn't realize that. I didn't think of this a couple of weeks ago when these TROs first started. I should have. Let me catch up. Scotus! The actual solution we got that. Joe has only the best war story. People have said the best, only the best from Joe. Great story, great war stories. Everyone they're the best stories. The best stories. Just love pimping ain't easy. Rumble is past, Joe. What does that mean? Is past? What happened with Rumble? Uh, Rumble never went live. I think I fixed it. I came looking in here before. That's so weird. I think I fixed it. All right.
How do you?
Yeah, I did. I fixed it. Sorry. So bad at this. Miss Ignominy. Gifting 5 new members. I'm still feeling very guilty right now, but I think it's my fault. That's a new record? Is it a new record? That I'm 40 minutes late on Rumble. I was in a zone. I was in a groove. I was in this whole groove. This whole groove thing was happening. It was a groove. I'm so sorry. Right. Well, anyway, so that's basically how there'll never be another TRO again. I'm not going through again. I'm not. So I forgot to bow down to our glorious not cult. No one needs to bow down to me. Seriously. Rumble is not systematized. The ruling having to do with Mike Johnson pushing a CR bill that'll refund all the DOGE cuts. We're going to default on debt limit if we do. I didn't see that. I'm not sure what you're even referring to be honest with you. It is calling. It's not. It is. It's calling their bluff. You're going to win? Are you going to win? Oh, okay, then put the money up. Put the money up and you'll win. If you win, you'll get your money. And if not, then we'll collect from you. Should judges start to disappear? I don't know. I don't even know what that's supposed to mean. Love you for your transparency. Great show. I'm so embarrassed. I feel so bad. I feel so bad. This is what I'm going to do, Rumble people. Seriously, this is what I'm going to do. Because I feel really terrible. When I'm gonna be moving on to the second half, where I want to talk about the Trump's application to the Supreme Court. But after I finish up, I'll close out the show on YouTube, and I'll run through my whole idea, and basically I'll synopsize what I was saying for the last 40 minutes for you guys on Rumble, so this way I don't leave you like high and dry. And I spent the last 40 minutes walking through the injunction bond rule, which is the methodology for how Trump can basically ensure that all these states, that none of these TROs that are stopping DOGE ever get off the ground at all. But I can't do it again to YouTube. That's not fair. So what I'll do is when I wrap up over here, I'll cover Trump's Scotus application to get rid of Dellinger. And when I wrap up there, I'll wrap up on YouTube, and then I'll review for Rumble. That's the best way to do this. That's the smartest way. And that way I don't feel guilty. It was me. It was my fault. What happened was the reason Rumble got started late is because I was because when I was putting together my show, normally I set up the Rumble link first, and I ended up doing the Rumble link after, and I forgot to sync in StreamYard to Rumble. So it was on me. So, but that way you're not missing anything, and I'm also not boring the hell out of YouTube by saying the same thing twice. So I think that's the smartest way to do this. But I have a new sponsor. That's true. I do have a new sponsor. Brand new sponsor. I'm very excited about this sponsor. brand new sponsor. I could bring out a second sponsor. I actually have up there that if I get 15 yellows in YouTube, I'll bring out my second sponsor. But I have my first sponsor for tonight. I have a sponsor who's sponsoring the show, and I think it's a good time for me to share with you all my sponsor here. They send me a commercial, and right. So now a word from our sponsor.
You probably thought this deer was alive, and this coyote was alive, and this pheasant was alive. Nope, they're not. They're dead. They've been taxidermized by Chuck Testa. Ojai Valley Taxidermy. I specialize in the most lifelike dead animals anywhere. Period.
Look at that antelope driving a car.
Nope, it's just Chuck Testa.
Oh no, there's a bear in my bed.
Nope, Chuck Testa.
Hold on a second. There's a leopard feeding on an impala out on my deck.
Nope, it's just Chuck Testa with another realistic mount. Shipped to me from anywhere. Call Chuck Testa for the most lifelike dead animals around, period.
Did that rhino just order a drink?
Nope.
Chuck Testa does not.
So please make sure if you have, for all your taxidermy needs, please make sure you contact Chuck Testa. Chuck Testa can be reached at 646-7482, especially those of you in the Ojai region of California, for all of your taxidermy needs. If it's not a bear in your bed, it's Chuck. It's Chuck. I don't really understand that reference. It's not a bear in your bed, it's Chuck Testa. There you go. All right. Seriously, for all of your, whether you need pheasants, leopards, bears, all of your taxidermy needs, please contact Chuck Testa. Don't feel bad. Get glad. Wait, wrong commercial. That's not right. Elon posted SS ages. One is 300 years old. I don't know what SS is. Oh, Social Security ages. So there you go. So if you want to sponsor the show, please, we have very, very affordable rates if you're looking to sponsor an episode of Good Logic. So I have a whole bunch of sponsors now, but I can manage this. I'll probably manage to squeeze you in. So. All right. We should talk about this new filing here. Donald Trump is running to Scotus, seeking to keep out Hampton Dellinger from serving as special counsel in the Office of Special Counsel. I don't even. It's a family show. Okay? It's a family show. Everyone's got different needs. All right. It's a family show. God dag nabbit, it's a family show. All right. Where was I? All right. Supreme Court application. Scott Besson, Secretary of Treasury versus Hampton Dellinger. Application to vacate the order issued by the United States District Court for the District of Columbia. Yes, issued by Judge Chutkin, that same judge. Crazy person. Applicants are Scott Besson, Secretary of Treasury, Sergio Gore, Director of the White House Presidential Personnel, blah, 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 including Donald Trump, and Russell T. Vogt, Director of Office of Management and Budget, where they're just trying to fire Hampton Dellinger. Pursuant to Rule 23 of the Rules of this Court and All Writs Act, 28 U.S.C. 1651, the Acting Solicitor General, on behalf of applicant Scott Besson, et cetera, respectfully request an immediate administrative stay of the District Court's order pending the Court's consideration of this application. What was the District Court's pending order? They said you have to let Hampton Dellinger back into his job as special counsel for the Office of Special Counsel. Special counsel for the Office of Special Counsel. Yeah, I know. It sounds very repetitive, but that is what it's called. What is the Office of Special Counsel? You might be saying to yourself, what do they do? What does he do? So he's an attorney. Basically, the Office of Special Counsel, primarily they serve. Well, I'll share with you what Grok says they do, so this way we're all on the same page as to what his potential damage could be if he stays in the role. The Office of Special Counsel is an independent federal investigative and prosecutorial agency within the United States government. Its mission is to protect the rights of federal employees, particularly whistleblowers. Now, we've seen how the Democrats play fast and loose with whistleblowers. When the whistleblowers who are coming after Donald Trump, they are sanctimonious, held on high, and have to be, respect the whistleblower. And when the whistleblower is exposing Joe Biden, it's like, let's dox them as much as we possibly can and hopefully, throw them under a railroad car. But so this guy, who's obviously very expert at it, considering what a crappy job he did protecting whistleblowers who went after Trump, from prohibited personnel practices such as retaliation for disclosing wrongdoing, here are some key aspects. There's whistleblower protection, there's prohibited personnel practices, which is prosecutes violations of laws, regulations that prohibit certain practices in federal employment, such as discrimination, nepotism, and reprisal for lawful disclosures. Hatch Act enforcement. Hatch Act enforcement is that you can't mix your personal with your political life, which, by the way, just so you know how lunatic the Democrats are, there have already been claims that when Musk wore a "Make America Great Again" hat in the Oval Office for that little press conference about DOGE, that people were some yahoos were claiming that's a violation of the Hatch Act, because you're not allowed to wear political clothing when you're serving you're not allowed to wear clothing that's promoting a particular political agenda when you're serving in public life. That is the Hatch Act. Also, Uniform Services Employment and Reemployment Rights Act, which is not really much of a concern about what he's going to do. And then it's supposed to go running to Congress on their activities and recommendations for legislative change. The point is, this guy can become a major pain in the neck if he's left to linger around, and he seems to be pretty crappy at his job, considering what a terrible job he did in whistleblower protection over the last couple of years. So Trump wants him gone. This case involves an unprecedented assault on this. This is the moving papers brought by Trump's team. Unprecedented assault on the separation of powers that warrants immediate relief. As this court observed just last term, Congress cannot act on and courts cannot examine the president's actions and subjects within his conclusive, and preclusive constitutional authority, including the president's unrestricted power of removal with respect to the executive officers of the United States whom the president has appointed. Trump v. United States. You know what that? There's a lot of cases that are called Trump v. United States. This is a reference to the immunity order that he got. They said president has immunity, and you can't start looking in the court. Neither the court nor Congress can examine what his actions are with respect to removing people. As to such principal officers, the most important of his subordinates, the president's management executive branch requires him to have unrestricted power to remove them in their most important duties. Enjoining the president and preventing him from exercising his powers inflicts the gravest of injuries on the executive branch and the separation of powers. What the hell Judge Chutkan thinks she's doing, Lord only knows. In the last 5 years, this court has twice held that restrictions on the president's authority to remove principal officers who serve as the sole heads of executive agencies violate Article 2 of the Constitution governing the executive branch and the president. In those cases, the single heads of the Consumer Financial Protection Bureau and the Federal Housing Finance Agency. Whatever the agency, though, for the president to discharge its constitutional duty to supervise those who exercise executive power on his behalf, the president can remove the head, lop the head off of an agency with a single top officer at will. At will. On that basis, President Biden in 2021 fired the single head of the Social Security Administration without cause. He just said, I don't like you. Goodbye. You can do that. He can say, I think that your name Hampton is really pretentious and kind of stupid. Thus, when President Trump on February 7th removed Respondent Hampton Dellinger as the single head of the Office of Special Counsel, he engaged in an uncontroversial exercise of Article 2 powers. Since the Carter administration, the executive branch has repeatedly expressed the view that tenure protections for the head of the Office of Special Counsel violate the Constitution. This is because the agency represents a particular clear-cut case. Investigative and prosecutorial decision-making is the special province of the executive branch. Constitution vests that power with the president. The Office of Special Counsel operates as a self-described investigative and prosecutorial agency. Well, who picks the head of that? The president. Elections have consequences. Brian Ogden, new member of the following. Welcome aboard, brother. Consequences. Brian Ogden, new member of the following. Welcome aboard, brother. Seriously. Consequences. Brian. Seriously. Yee. If you want John Rumble. Minatika says, not enough to guilt you in paying attention to Get Up for the Future, but whatevs. You know, I'm doing right by you. I'm going to work double. It's the same show for you. It's just an opposite order. It's all good. President's removal of respondent accordingly implicated two preclusive presidential powers, the power to remove and the power to control investigative and prosecutorial decision-making. He alone, this is his province alone. Yet, within hours of respondent filing suit, and before the government had the opportunity to respond, the district court issued an 8:35 p.m. order on February 10th, labeled as an administrative stay. That's what Judge Chutkan did. That order restored respondent to the office which the president had removed him, enjoined any efforts to impede his access. That was part of the executive order, of the temporary restraining order. You have to give him immediate access right now. It's insanity. To resources, materials of the office, and barred the president from installing any other person as special counsel. On February 12th, the district court enjoining the president and other senior executive branch officials and restoring respondents to office. The court set that TRO to last a full 14 days and specified that a hearing on an appealable order would not be held until February 26th. They basically said, sit there and eat it. And a TRO is supposed to last a couple of days. 14 days is insane. I've never heard a TRO lasting 14 days. Until now, as far as we are aware, no court in American history has wielded an injunction to force the president to retain an agency head whom the president believes should not be entrusted with executive power and prevent the president from relying on his preferred replacement. Yet, the district court remarkably found no irreparable harm to the president if he's judicially barred from exercising exclusive and preclusive powers of the president for at least 16 days, and perhaps for a month. See Federal Rules Civil Procedure 65B2. And when the United States sought a stay, or alternatively mandamus, the D.C. Circuit issued a 27-page decision denying relief late on Saturday night over Judge Katz's dissent. So we went to the D.C. Circuit Court saying, hey, what the hell's happening here? And the court ruled against us. Judge Katz's dissented, but the other D.C. Circuit courts, they should close down that whole court. That whole D.C. Circuit court should just be vanished. So now the United States seeks this court's intervention because these judicial rulings irreparably harm the president. As Judge Katz's observed, and they're going to cite Judge Katz's a lot in these papers, which is the right thing to do. You cite the dissenting judge. The TRO, which operates as an injunction against the president and requires him to reinstate an agency head whom he removed, is virtually unheard of, usurping a core Article 2 power of the president. Courts may not enjoin the president. They actually have no business even thinking about this. That's the point. They have no business even thinking about this case. May not enjoin the president regarding the performance of his official acts regarding removal or otherwise. Even when courts do not enjoin the president himself, the court has long held that a court will not, by injunction, restrain an executive officer from making a wrongful removal of a subordinate appointee or restrain him from the appointment of another. Meaning, even if he was firing someone because he was racist, you're still not allowed to stop him. You still can't stop him. Thus, challenges to removals, which I don't even think Hampton is. I think Hampton is white. I'm assuming from that pompous name of his that he must be white, right? Hampton Dellinger. That dude's got to be like. That guy's like powder, I'm sure. Hampton Dellinger. Oh yeah. Yeah. I guess the name Brad was taken already. All right. This court should not allow lower courts to seize executive power by dictating to the president how long he must continue employing an agency head against his will. Where a lower court allegedly impinges on the president's core Article 2 powers, immediate appellate review should be generally available. This is their way of saying, take our case. Take our case. Yet the D.C. Circuit Court majority described waiting 2 weeks to exercise that executive power as not so prejudicial. No big deal. And that's why we need to close down the D.C. Circuit Court. Seriously. Just fold it up. Fold it up. If that reason is allowed to stand, it is hard to conceive of any TRO that would trigger appellate review. Such a ruling risks further emboldening district courts to issue TROs enjoining the president from undertaking myriad other actions implicating executive powers. Like, what are you not going to stop him from doing? That's no mere hypothetical. District court's order exemplifies a broader weeks-long trend in which plaintiffs challenging President Trump's initiatives have persuaded district courts to issue TROs that intrude upon a host of the president's Article 2 powers. A district court in New York issued an ex parte TRO requiring the access to certain Treasury Department data be limited to civil servants and be denied to political appointees. when they go through the list of the different TROs, which we've been documenting for the last several weeks. The United States thus respectfully requests the court vacate the district court's order. And so it begins. It's 10 o'clock here on the West Coast. If your kids are watching on Sunday night, you're not family friendly. Is it really 10 o'clock already? Man. It's 10 o'clock already. All right. Congress established the Office of Special Counsel and Civil Service Reform Act in 1978. The office began as the investigative prosecutorial arm of the Merit Systems Protection Board. Who ever heard of that? The Office of Special Counsel remains an investigative and prosecutorial agency. There are certain provisions of they execute certain provisions of 4 federal statutes governing the federal workforce: the Civil Service Reform Act, Whistleblower Protection, the Hatch Act, and USERA, which is Uniform Services Employment and Reemployment. The office promulgates regulations, receives and investigates allegations of wrongdoing, and brings disciplinary actions when a meritorious case cannot be resolved through negotiation with the agency involved. Similarly, its Hatch Act unit seeks disciplinary actions before the SMPB, et cetera, et cetera. We don't really, frankly, to me, the big concern of having Hampton there is it's really about this part right here. It's about the whistleblower protection and about the Hatch Act. Civil Service Reform Act could play in. It's probably third. In 2023, the Office of Special Counsel had 120 full-time equivalent employees, 31.9 million appropriate funding. Office received 4,611 new cases that year. They average 5,900 cases. We're expecting it to get bigger. And it's headed by a special counsel. Special counsel is appointed by the president with the advice and consent of the Senate for a term of 5 years. Special counsel has statutory authority to appoint subordinate agency personnel. So this is a whole confirmation thing to get him replaced. The Civil Service Reform Act provides that special counsel may be removed by the president only for inefficiency, neglect of duty, or malfeasance in office. Now, this is what Judge Chutkin and the crazies on the left are relying on. Well, Congress wrote a statute, and that statute says you can't remove him. As if Congress can create a statute that overrides the Constitution. To the extent it's inconsistent with the Constitution dictates. You don't get to say, oh, well, Congress passed a law, and that law says it stays there for 5 years. You can't only remove him for inefficiency, neglect of duty, malfeasance. Since 1978, there have been constitutional objections to that restriction. For instance, in the Carter administration, the DOJ's Office of the Counsel explained that because special counsel would be performing largely executive functions, Congress could not restrict the president's power to remove him. Reagan pocket vetoed a bill on constitutional grounds because the bill would have vested the Office of Special Counsel with additional powers. The government filed a brief in this court in 2020 explaining that the president must have the power to remove at will the single head of the Office of Special Counsel. In March 2024, Biden, with the advance consent of the Senate, appointed Hampton Dellinger. So this guy just was brought in here down the stretch by Biden. On February 7th, threat to the White House, president informed respondent that President Trump had removed him from office effective immediately. So we told him, you're fired. You're fired. Get out of here. No one needs you. Get the heck out of here. On February 10th, the following Monday, respondent brought this suit in the U.S. District Court, District of Columbia, to challenge his removal. Before the government could respond, the court held a near immediate hearing. Hours later, the court entered what it described as a brief administrative stay, a brief 16-day stay. That is so not brief. Brief stay is 2 days, 3 days, 16 days. They'll last until midnight, February 13th. That order restore respondent of the post of special counsel and said you cannot deny him access to the resources materials. Ridiculous. They want to give him time to shred the papers. That's what it is. The next day, the president designated Secretary of Veterans Affairs Doug Collins as acting special counsel. We like Doug Collins. He's good. But the court's order prevented the executive branch from giving effect to that designation. The government appealed the administrative stay to the D.C. Circuit Court, sought a writ of mandamus, and sought a stay of district court's order. Court of Appeals dismissed the appeal for lack of jurisdiction, denied mandamus, and dismissed the motion for stay. They told us, go jump in a lake. In a concurring opinion, Judge Katsas indicated district court's administrative stay was not immediately appealable, but he emphasized he expressed no view on the appealability of or merits of any later order granting interim relief to respondent. On February 12th, the district court issued what described as a TRO. The order said that until the district court rules the entry of preliminary injunction, respondent shall continue to serve. He's going to stay in there. And applicants may not deny him access to resources and materials. He's got to have access. Why? What does he have to do that's so urgent? In issuing that order, the district court found that respondent was likely to succeed on the merits, which is astonishing. She displayed her incompetence by saying likely to succeed. The court acknowledged this court's decisions regarding the president's broad authority to remove officials at will, but concluded the reasoning underlying the decisions does not extend to the unique office and official involved in this case. This office, very, very different, very different. The court stated the Office of Special Counsel has no authority over private actors, does not have broad rulemaking authority, or wield substantial enforcement authority. But it's essential that he stay there. It does not affect a broad swath of the American public or economy. So, turning to the equities, the district court accepted respondent's contention that he faced irreparable harm because he was deprived of his statutory entitlement to serve as the lawful agency head. How is that irreparable harm? Held that the balance of hardships in the public interest favored respondent because the government proffered no circumstances that require the president's hasty, unexplained action. Same day, the government again appealed to the D.C. Circuit Court and sought a writ of mandamus. Next day, the district court denied the government's motion for a stay. The point to this is we got nowhere else to go but to you, Supreme Court. In a lengthy opinion issued late on Saturday night, February 15th, the Court of Appeals once more dismissed the appeals. Look at this. That happened yesterday. Saturday night. The Court of Appeals dismissed the appeal for lack of jurisdiction, denied mandamus, and told us GFY. The court reasoned preliminary injunctions are appealable, but TROs generally are not. The court acknowledged that a TRO may be treated as an injunction when it has irreparable consequences and warrants immediate relief, but that the harm to executive branch here does not qualify. Let's just fold them all up. The court observed district court plans to hold preliminary injunction hearing February 26th, and that waiting 2 weeks to exercise the executive Article 2 prerogatives is not so prejudicial. Oh, it's not? It's so urgent that he must be there and have access every single day. This is how twisted and sick DC is, how twisted and sick they are. So it's absolutely essential that he has to spend every 10 seconds that he has the official role, that you can't deny him access. That's absolutely essential. But waiting 2 weeks for who's going to be in charge there, that's not really such a harm to the government. What the hell? It's so freaking convoluted. It's so transparently corrupt. Sickening. Those are sick people. Make it make sense. Someone make it make sense to me. How can it be, if this job is so important that he cannot be restrained from doing it for 10 minutes, you must grant him access immediately because it's so essential he get in there. If that's how vital and critical this job is, then how can you tell me that waiting 2 weeks is no big deal? It's 2 weeks at this critical job. So convoluted. So they explain they're likely to succeed on the merits. An applicant likely to success an applicant's likelihood of success in merits is the most important determinant for the emergency relief. Out here, the likelihood is very high because we got, Article 2, which kind of trumps any stupid congressional act. Time again, this court has held the president has unrestricted removal authority. No one questions that. Executive power generally includes the ability to remove executive office officials. See Silo Law LLC. Otherwise, the president cannot be held fully accountable for discharging his own responsibility. How is he supposed to do his job if he can't even decide who's going to be in charge of various agencies? His power to remove comes straight from the text of Article 2. The president's power to remove cannot be regulated by Congress or reviewed by the courts. You have no business even looking at this based on what the Supreme Court said in Trump v. U.S. back last June. Applying this general rule, it might be July 1st. Don't quote me on the June thing. The court has repeatedly held in recent years that the president must be able to remove all, at will, sole agency heads. Get them out of here. As a general matter, the Constitution scrupulously avoids concentrating powers in the hands of any single individual, save for the president, who is the most democratic and politically accountable official in government. So these single agency heads must be accountable to the president through at-will removal. Strong argument. It's compelling. The only people who have tenure are directors of Consumer Financial Protection Bureau, Federal Housing Finance Agency, and Consumer Commissioner of Social Security, and special counsel here. The former three are undisputedly subject to at-will removal. The other three we definitely know can be removed. This court's precedents foreclose any special exception for the special counsel. This is the only job you can't fire him from. So Congress tried giving, what the point that they're making is, this is not the first time Congress tried saying president can't remove it. These other three single heads, the CFPB, the FHFA, and the head of Social Security, they said, you can't remove them. Well, you know what? The Supreme Court said, yeah, you can. So now we have this special counsel, the Office of Special Counsel. There's no reason it's any different. And I go through how all four of them were deemed to be removable. Go through CFPB and the FHFA. And then the Commissioner of Social Security. All of these folks, all of them, the court said can be removed without cause by the President of the United States. Granting a special exception to at-will move for the special counsel would plainly contravene these precedents. Good stuff. And they start explaining how the Office of Special Counsel does wield executive power. He's part of a prosecutorial agency. Classic executive branch stuff. Executive branch material. They proudly trumpet that they can investigate allegations of prohibited personnel actions, and they also enforce multiple statutes by bringing disciplinary actions and litigating complaints before the MSPB. Those are all executive functions, and accordingly, he's under Trump. At the outset, let's move forward. And accordingly, referring to the special counsel as being tenured is unconstitutional. The executive branch has repeatedly objected to that protection since the enactment of the Civil Service Reform Act of 1978. This is not a new thing that the executive branch has been complaining about. Trump's not the first one. Even Carter was complaining, saying it doesn't make any sense. In 1988, Reagan pocket vetoed a bill that would have vested the special counsel with more powers. saying that it's got serious constitutional concerns and that it purports to insulate the office from presidential supervision and limit the power of the president. All of a sudden, he's going to be like another, like, sort of quasi-president in these domains. It makes absolutely no sense. This also came up during the first Trump administration. That the president must have the power to remove at will single heads of the Social Security Administration Office Special Counsel. So the district court says in Court of Appeals, contrary reasoning defies these court precedents, and they basically don't care about, because the D.C. Circuit doesn't care about precedents. And the district court said that the reasoning underlying seal law in Collins doesn't extend to the unique office and official involved in this case. Oh, this is totally different because it's Trump trying to remove him. And that the Office of Special Counsel cannot be compared to those involved when this court found the removal for cause requirement to be unconstitutional intrusion on presidential power. Totally different. This court's precedents recognize a general rule of unrestricted removal subject to only 2 exceptions. The court concluded that Congress should provide tenure protection to a multi-member body of experts balanced along partisan lines that perform legislative and judicial functions and was said not to exercise any executive power. That's the only time if there's no executive power. Second, the court has concluded that Congress can provide tenure protection to certain inferior officers with narrowly defined duties. Those 2 exceptions represent the outermost constitutional limits of permissible congressional restrictions on the president's removal power. Outside of that, Congress can go to hell, and they can't do anything about who the president wants there. The district court should not have asked whether those cases applying that general rule, such as seal law and Collins, should be extended to the special counsel. Rather, it should recognize that the rule that the president can remove principal officers, and you need to find a way around that problem. But she never bothered that. She looked at it as like, well, does your rule here apply over here? No, we start with an assumption that the rule applies, and if it doesn't apply, then the court has to find a reason to say it doesn't apply. It should have recognized the rule, and that should have ended the matter, especially since the only exceptions this court has recognized the president's unrestricted removal power are inapt, meaning they don't apply here. These are good papers. These are well-written papers. Regardless, the reasoning underlying this court's recent precedent does extend. Those precedents establish a bright-line rule. The Constitution prohibits even modest restrictions on the president's power to move the head of an agency with a single top officer. The district court dismissed seal law and Collins on the ground that the special counsel exercises limited jurisdiction and deals with the small subset. Who the hell cares if it's a small subset of federal employees? Does not have broad rulemaking authority or wield substantial enforcement authorities. So she's trying to find some way that she can try to find a distinction as to why this is the only job in the entire executive agency that he has no authority on. Oh my God. This is activist judge. Such an activist judge. Article 2 contains no exception for limited exercise of executive power that poorly affect only small groups of people. She made that up. Literally made that up. Who cares whether it's small groups or large groups of people? That's not a distinction anyone ever made before Judge Chutkan came up with it. The special counsel executes multiple federal laws by investigating allegations of wrongdoing, issuing subpoenas, bringing disciplinary actions, and participating in proceedings before the Merit Systems Protection Board. District Court emphasized that in seal law and Collins, this court did not comment on constitutionality of any removal restriction applicable to other agencies that were not before the courts. But a court, by announcing that its decision is confined to the facts before it, does not decide to advance that logic, will not drive it further when new facts arise. All right. I think we got the point, right? Let's go down a little bit here. Let's get down to the Court of Appeals logic. They didn't explore the merits, but they did invoke the presumption of constitutionality that ordinarily attaches to a duly enacted statute. This court has never invoked that presumption in interbranch disputes concerning the removal of power because it does not apply. So, what does this mean here? You might be a little confused by this. Let me try and explain it to you. What does this mean? The Court of Appeals came with a different approach. When they were trying to protect Judge Shutkin and her protection of Hampton Dellinger, they invoked a presumption of constitutionality. And they say, look, here's a statute, and we're going to just start with an assumption that the statute must be constitutional. So when you're sitting here saying that this statute is unconstitutionally impeding on Article 2 by restricting his ability to remove an agency head, we're just going to start with an assumption that we just assume that they're all constitutional. And if there's a statute that was passed, we'll assume it's constitutional. This court has never invoked that it's not easy to do this. Has never invoked that presumption in interbranch disputes concerning the removal power because it doesn't apply. Where the issue pertains to separation of powers and the political branches as here in disagreement is a disagreement between Congress and the president as to whether or not Congress has this power. Neither can be presumed correct. So you don't start with an assumption that it's constitutional when Congress says we have a right to force this upon the president. The president says you don't have a right. We don't assume that Congress is right just because they pass statutes. The reason is stated concisely by Madison. The several departments being perfectly coordinated by the terms of their common commission, neither of them, it is evident, can pretend to an exclusive or superior right of settling the boundaries between the respective powers. Court cannot assume and start with an assumption, well, if this is a statute that passed, it must be valid. There's no such thing when you're trying to define the outer limits of each one's power between Congress and the president. Congress and the president are in conflict here. Do they have a right to give this agency head tenure where he's not fireable unless for good cause, but for no cause that the president's restricted, or do they not have the power to do that? We don't start with an assumption. Well, because it's a statute, it must be constitutional. The playing field for the present case, in other words, is a level one. There's no assumption in Congress' favor. As one interested in coordinated parties, the underlying dispute, Congress, no more than the president, is entitled to the benefit of doubt to assume that this statute is any good. So stop with that nonsense. Just stop with the nonsense, circuit courts. Worse, the district court's orders do not just enjoin the president from firing the special counsel. The court order strips the president of even the authority under the statute to remove the special counsel for inefficiency, neglect of duty, or malfeasance in office. According to her, she's like, no, you can't fire him no matter what. The court order provides categorically that until the court rules on the entry of the preliminary injunction, plaintiff Hampton Dellinger shall continue to serve as special counsel, no matter what he does, even if he starts attacking people in the halls. You can't do anything. Can't fire him, according to her. The district court's order thus raises the prospect that even if the president wished to fire a respondent for cause, in conformity with the statute, that she's putting a tighter rein on him than the statute does. Statute says the president can fire him for cause. According to her, during this period of time, he cannot fire Hampton for any reason. he would first need to ask the court to modify its order, which that itself is a violation of separation of powers. The Court of Appeals appeared to view that prospect with equanimity, stating that the order is not irreversible, and the district court can allow the president to remove Dellinger if the court so chooses. Unbelievable. But that demand for judicial preclearance represents a further and unprecedented intrusion on presidential oversight of the executive branch. So basically, when it comes to the executive branch, Congress can decide what it's going to do with it, the court, everyone can just decide. The first Congress rejected the idea the president would need to obtain the Senate's advice and consent to remove a principal executive officer. No one imagined that the president might need to obtain the advice and consent of a federal district court. These judges it's like such an asinine claim of assertion of power. No, you can't fire him unless I give you approval. It's crazy. Having contravened this court's removal precedents, the district court defied the court's remedial precedents as well. Courts cannot enjoin the president, yet the district court's order here requires undoing the president's removal decision and bars the president from appointing anyone else. The court recognized long ago that court has no jurisdiction of a bill to enjoin the president in the performance of his official duties. It goes back to 1867. An injunction preventing the president from firing an agency head and thus controlling how he performs his official duties is virtually unheard of. But that's the world. That's the judiciary in 2025. Absolute embarrassment. District's court order necessarily enjoins the president from removing the special counsel from appointing someone else by directing that Dellinger shall continue to serve as the special counsel, and defendant may not recognize the authority of any other person as special counsel. Who the hell this woman thinks she is? Embarrassment. Court of Appeals sought to avoid that problem by interpreting the terms defendants to refer only to other defendants, but not the president. Yeah, it's not talking about the president, but that's no answer. The TRO necessarily targets the president, the only official with the statutory and constitutional authority to appoint. Who the hell else is she talking to? Talking to the freaking janitor saying you can't appoint a new person? Whether the order is expressly directed to the president or not, this court's precedents reinforce that courts lack the power to issue any order reinstating a principal executive order removed by the president. When executive officers have challenged the removal by the president, they have traditionally sought back pay, not reinstatement that they get to come back. Stupid. So aggravating. That rule reflects the obvious Article 2 problems that arise if a court attempts to reinstate a principal executive officer removed by the president. So what, he can seriously commit treason and you can't fire him, according to Judge Hutkin. Oh, please, Judge Hutkin, can I please fire him? He committed treason. That's what she said. That's what she said. If he commits treason, you can't fire him. You can go in there with a bazooka, start like blowing people away. He needs to go to the court and say, "Can I please fire him now?" Lunatic. The president cannot be compelled to retain the services of a principal officer whom he no longer believes should be entrusted with the exercise of executive power. Going all the way back to the first Congress. When they say the first Congress, they mean the first Congress. They argued against requiring the Senate's advice and consent for removals precisely because of the risk that such procedure would require the president to retain someone he had sought to remove. As Representative Benson observed, if the Senate upon its meeting were to acquit the officer and replace him in his station, the president would then have a man forced on him who he considered as unfaithful. Representative Boudinot argued, but suppose the Senate shall decide in favor of the officer, what a situation is the president then in, surrounded by officers with whom, by his situation, he's compelled to act, but in whom he can have no confidence? Why are you going to put the president with people that he doesn't like? Representative Sedgwick, we're going a whole history lesson here. I like this. Representatives, going back to the first Congress, Representative Sedgwick asked rhetorically, shall a man under these circumstances be saddled upon the president who has been appointed for no other person but to aid the president in performing certain duties, and he's actually going to be a hindrance to him? Shall he be continued? Shall he be continued, I ask again, against the will of the president? The district court's extraordinary remedy raises just that problem. The district court's remedy also exceeds the scope of its equitable powers. The court has no power here. Federal court may grant only those equitable remedies that were traditionally accorded by courts of equity. When has any court ever been able to say the president can't fire someone? Reinstatement of a public official is not such a remedy. Well settled that a court of equity has no jurisdiction over the appointment and removal of public officers. Who the hell she thinks she is? Instead of jurisdiction, determine the title to a public office belongs exclusively to the courts of law, for instance, through suits for back pay. Meaning, if this guy Hampton says, hey, you didn't have any basis to fire me, I'm entitled to get paid, well then, okay, that's one thing. Not that he gets to sit back in it behind his desk again. The power of court of equity to restrain by injunction the removal of a public officer has been denied in many well-considered cases. They go through those cases here. Now, Congress has sometimes departed from that equitable tradition, and it has empowered courts to award reinstatement. For example, Title VII of the Civil Rights Act of 1964 empowers courts to grant reinstatement as well as back pay as remedies for employment discrimination. Respondent, however, cites no statute that authorizes court to reinstate a special counsel who claims to have been wrongfully removed. A court accordingly may not grant such a remedy. The creation of new remedies is a legislative endeavor, and who the hell this judge thinks that she has the authority to reinstate someone is asinine. Courts of equity lack the power to create remedies previously unknown to equity jurisprudence, meaning no judge has ever tried reinstating someone before, but along comes Judge Chutkin, and DC Circuit Court says, oh, good job. Oh, yeah, that makes total sense. All of them should be just on the wall. These principles apply even to removal of a municipal officer, meaning a much lower officer, and apply all the more to President's removal of a principal executive officer. Perhaps the most telling indication of the severe constitutional problem with the district court's remedy is the lack of historical precedent for it. We are unaware of any previous case in which a court ordered the reinstatement of a single agency head after removal by the president. At most, a district court in 1983 effectively reinstated removed members of a multi-member U.S. Commission on Civil Rights because that court believed that the commission functioned as a legislative agency whose only purpose was to find facts which subsequently be used as the basis of a legislative or executive action. But they had no executive power. There's no support for this in law. And this last part here, I think, gets a little repetitive as they start explaining why this warrants the court's review. So that's the meat and potatoes of this application here. I think it's a very well written application, personally. I think he's going to win this. I think the Supreme Court will take it. I think he's going to get it. Because this is just a ridiculous stretch of Judge Chutkin's power. So you can reinstate someone? Ridiculous. Makes no sense. Just illogical. Raising the original, that's an originalist perspective. Like, what were they originally thinking when they drafted the Constitution with respect to allowing people to come in there? That sort of thing resonates well with the likes of an Amy Coney Barrett. And she's one of the three you need to convince, because you know you're going to have Thomas Gorsuch and Alito on your side. So I expect that they're going to be successful here. That's my claim. I'm sticking to it. Please see Elon's ex post tonight. If accurate, these are grounds for impeachment of the judge. His thing tonight. What did Elon say tonight? I can look that up. Good Elon. Problem is, this guy tweets so much, like finding anything he says can take forever. Let's see what we can do for you, Salty. Oh, this is about Judge John McConnell, alleged. Federal Judge John McConnell failed to disclose his role at Crossroads, Rhode Island, while ruling against Trump's spending freeze. His nonprofit received $128 million in government funding during his 18-year board tenure, including $42 million from 2020 to 2023. Rhode Island, a plaintiff in the case, already sent his organization $2.9 million in 2025. The judge ordered federal funds to keep flowing to states and coincidentally to his own nonprofit. Federal law requires judges to recuse himself when their impartiality might be questioned. Wonder why he didn't. These are all the payments to Crossroads, Rhode Island. Yeah, he's not going to be impeached. Okay, he's not going to be impeached. At worst, he'll be censured. Should he recuse himself? Yeah, I agree. He should have been. He's not going to be impeached. I mean, even if he gets impeached, he's not going to be convicted by the Senate. So, you see all these judges, so many of these judges who have these ridiculous links to the case that they're presiding over, they never get impeached for it. So, good question though. Black Dragon, when will these Democrats be held accountable for their illegal and unconstitutional behavior? Abusive process is that unconstitutional? I can't. I understand your frustration. I'm going to assume this is a rhetorical question because I don't know. It's frustrating. I get it. It's very frustrating. But the problem is that they're supported by idiots. They have countless useful idiots. And all these Democrats know that they're going to forever have these useful idiots. I appreciate your ability to turn any book into a coloring book. I heard your biggest expense is law school was highlighters. It was very expensive. Yeah, there was. Everyone uses a ton of highlighters, though. At DebateCon tonight, Pisco tried to lie and say the Humphrey executive case didn't allow the president to fire executive appointments. Good old honest Pisco. Yeah, they should have had me at DebateCon. But when I reached out to DebateCon and offered to debate, they said they have 1 million conservatives and no liberals. They can't. They're like, we have tons of conservatives. Still, between you and me, they relied on Alex Stein for a lot, and I was just like, he's okay. He's okay. I did meet this guy. Some of you may know this guy. I didn't meet. I mean, on Space tonight. In fact, I'm going to send him a. I'm to be a fan of his work. The older millennial. Do you guys know who this is? You know who this is? I'm going to be a fan of his. This guy.
Speech caused the Holocaust? That's at least.
Oh, this is a new one. He puts out a lot of work.
Did y'all know that freedom of speech caused the Holocaust? That's at least what CBS reporter Margaret Brennan thinks. Here's what she told Secretary of State Marco Rubio.
Well, he was standing in a country where free speech was weaponized to conduct a genocide.
She literally said that all emotional and shit, like as if what she was saying had depth, claiming that what the mustache man used was freedom of speech, when really what he did was restrict the freedom of speech, as well as the right to assembly, the freedom of the press, and so many other fucking rights. He also removed restraints on police investigations. They were free to arrest and incarcerate political opponents without charges. Guys, I don't think there's ever been a better example of the media telling you to shut the fuck up. Because why else would you try to pretend that the reason the genocide in Germany happened was freedom of speech? CBS, you need to fire this person. Because what the fuck? Did y'all know that?
So I was with him on a space.
To spend billions of our tax. Do you fucking liberals recognize that the main cause you're fighting for right now is for the right of unelected bureaucrats to spend billions of our tax dollars in other countries? That's the side you're on right now. That's what you're making videos about. That's what you're writing articles on Substack about. That's what you're protesting for. That's what you're filing lawsuits to make sure happens. Are you fucking stupid? Imagine if I had told you 10 years ago that in 2025, the thing liberals in America would most be fighting for is for billions, if not trillions of dollars of their money to be spent in other countries on things that don't benefit America in any fucking way, while America goes farther and farther into debt. What if I had told you 10 years ago that you'd be fighting for the right of politicians to be able to line their pockets with bullshit payments to bullshit programs in bullshit countries? You wouldn't have believed me. That's where we are. That's what you're fighting for. And what you're fighting against? You're fighting against people who just want to audit our government, who just want to audit our governmental agencies, people who just want to see where we're spending money, where we're wasting money, and where we're committing fraud. And you're fighting against that. Are you out of your fucking minds?
So that's the older millennial. And he added me now tonight so that I can get him on here. I'm going to try and get him on some night this week, maybe Wednesday. We'll see. We'll see. I'll drop him a DM and try and work out what times work for him. But yeah, that's going to be coming up this week. So, yeah. I think he's going to be a fun guy. I think it's going to be good. It's going to be good. I think it's going to be good. You guys are all such haters. He's not trying to reason with them. He's making the point to he knows his audience is conservative. He knows his audience is conservative. All right. Anyway, I need to start explaining to Rumble why it is that Trump is going to be able to get rid of his TROs, assuming his attorneys make the right call. Which means I need to wrap things up here on YouTube. So that's what we're going to do now. So those of you on YouTube, time for me to head over to Rumble and serve the ghetto. I have to serve the ghetto. I come to you serving you ghetto. I come to you ghetto. I'm gonna be visiting in your little hovel there. Probably indoor plumbing there. I don't know what they got going on there. What do they have in the ghetto? What do they have in the ghetto? I don't even know. Anyway, tomorrow I'll be here. Eclair Trio, God willing. I'm going to the ghetto because I missed them the first 40 minutes when I was walking through how to beat these TROs. So I'm going to go over it with them again. But yeah, I will be back here tomorrow evening. And yeah, it's going to be a good show tomorrow. So make sure that you're here on time. Don't be late tomorrow. Tomorrow's going to be a good show. It's going to be a good one. Till then, for YouTube folks, hasta la vista, baby. It's great seeing you. You know what they say. Lab meat, they, them. Bugs, you, gross, no, don't do it, don't touch it. And yeah, I'll see you tomorrow. Till then, good night and Godspeed.